Executive Director Susan Myers and the investigative, training, and administrative staff are in the Salem office. So is the Commission's counsel from the Oregon Department of Justice, Sean Brady. As for commissioners, my name is Dave Fiscum, and I currently serve as chair of the commission, and I'm in the Salem office this morning. Vice Chair Shanoa Payne is online. Commissioner Dan Mason is online. Commissioner Jonathan Thompson is in the Salem office. Commissioner Rick Burke is online. Commissioner Alicia McCauley is online. Commissioner Yvonne Resendez Gutierrez is out of town today, thus unable to attend this meeting. Commissioner Ann Medler is online, and Commissioner Peter Jancy is online. So, colleagues, we have a quorum. Regarding Commissioner Jancy, pardon me, if you can hear me, Commissioner, you have now a new first name. It is Commissioner. Welcome to your first Ethics Commission meeting. We're glad you're here. And for the first time in a while, your appointment brings us up to a full complement of 9 commissioner members. So, Commissioner Jancy, would you do us just a quick favor and introduce yourself to us and give us just a brief summary of your background in a few seconds as we welcome you to your first meeting? We're glad you're here.
Thank you, Chair. Glad to be here. And again, my name is Peter Jancy. I'm an attorney in civil practice, living in Portland, Oregon with my wife, and glad to have the opportunity to try to be of some service. So,
Commissioner, thank you for your comments. We appreciate it. And again, we're glad you're here. Otherwise, regarding today's agenda, you'll perhaps will be glad to know that I do not have any comments from the chair today, so you can take that relief. Our executive director, in fact, in her report later on today, will bring us up to speed on the status of legislative issues, including our agency's budget. Frankly, Becky Mason has left for the Capitol because that budget is up this morning in Joint Ways and Means, and she'll be back in theory in time to give us an update on that later on. Just a quick official reminder for all of us, including me, be careful for side conversations because our system is sensitive enough to pick up many of those conversations on the record. So to the extent you can avoid doing that, please do so. Also on the public session agenda, are there any comments from commissioners pertaining to matters not on the official agenda for today's meeting? Looking for hands, seeing none at the moment. Let's move on. Our approach today will be to consider almost all items on the public session agenda first. We'll hold off on a matter involving the League of Oregon Cities, as well as our executive director's report for after the executive session. So once we get through with the public agenda, we will move, in fact, to the executive session and consider orders in the matter in which they appear on your agenda for executive session. Any comments, colleagues, on the approach today? We'll keep you posted on how we go through that. Hearing none. The next item is to consider the minutes of the meeting of April 25 that have been distributed to you. The time is now for comments on those minutes, or I'll accept the motion to approve those minutes as distributed.
Yes, Chair, thank you. I move that the commission approve the minutes of the April 25th, 2025 commission meetings.
Thank you, Vice Chair. Any comments on that, colleagues? The administrator will call the roll, please.
Commissioner Mason.
aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Metler.
Aye.
Commissioner Jancy.
Aye.
Chair Fiscum.
Aye.
Motion passed 8-0.
Thank you, colleagues. Chair, Executive Director, if I read the agenda right, there are no consent calendar items today. Is that right, or am I wrong?
That is correct, since our last meeting was only 2 weeks ago.
Thank you.
Didn't collect any in that short time.
I just want to make sure I didn't miss something on the agenda. So moving on in the public session agenda, we will now move to item number 4. By number 23-067 involving Steve Marks, the former executive director of the Oregon Liquor and Cannabis Commission. Our approach today will be to hear the report from our investigative staff and then move forward to hear any comments from Mr. Marks or his counsel. So we'll start with the report. Executive Director, please.
And Mr. Marks' counsel was planning to attend. but
Yeah, I have a note here that Mr. Marks' counsel, Mr. Bob Steringer, was planning to attend, so let's make sure that he's admitted.
We are working on getting him into the meeting. I do apologize. There's been a little bit of a hiccup.
We call those technology glitches. But in any event, let's just pause for a second and wait for Mr. Steringer to be here to hear the report that our executive director will give. Just let us know when Mr. Steringer is in the virtual
I will do.
room. Thank you.
I do believe Mr. Marks is in the room. At least he was.
Okay, I didn't know if Mr. Marks was attending, but that's fine if he is.
Right. Yes.
Did you touch the computer again?
No, never. I'll find my grandson.
Excellent.
Yeah, but like you're jumping on really short. Thank you. And Marks is in the room. Just sitting here.
Is Mr. Marks in room?
Mhm.
Okay, Mr. Steringer is on the way.
Mhm.
Thank you.
I believe he's joining us from his vacation, so
Mr. Steringer is, yeah, which is
very nice of him.
exactly. So I'll wait for the heads up to proceed.
The link. Mr. Steringer has joined. We're giving him permission to share his camera and his mic. So just one moment.
We'll wait a few more moments.
Okay, that should be allowed. Should be good now.
But,
Good to go.
okay, Mr. Steringer, Mr. Marks, can you hear me? Mr. Steringer, we see you now. Can you hear me?
Good morning, Chair Fiscom. Yes, I can hear you, and it's just me today. Mr. Marks will not be here.
Okay, thank you very much. For the record, as I said earlier, this is Dave Fiscom, the current chair of the Oregon Government Ethics Commission. This is the time set for the consideration of, on our public session agenda for May 9, 2025, our item number 4, which involves the number 23-067 involving Steve Marks, the former executive director of the Oregon Liquor and Cannabis Commission. The first step in our process is for our investigator, in this case, our director, Susan Myers, to make a report that we then can ask questions about before turning to Mr. Steringer. Executive, please.
Thank you, Chair, Commission. So item 4 is a proposed stipulated final order for the case involving Steve Marks. As you know, this is one of 6 cases that the commission opened and moved to investigation back in 2023, involving 6 OLCC employees. And the cases were suspended for quite a while because there was a pending DOJ investigation. Once that investigation last April concluded that with no criminal charges being brought, at that point, our investigations of the 6, including Mr. Marks, were reactivated because they had been in suspension, and we proceeded with our investigation. And during that process, at some point, Mr. Marks, through his attorney, requested a time waiver so we could explore if we could reach negotiated stipulated final order or settlement. What we have negotiated is before you, and it basically concludes that during the period of our jurisdiction, which was March 10, 2019 to March 10, 2023, Mr. Marks obtained 1 bottle of Pappy Van Winkle from OLCC's reserve stock. He paid the list price for the Pappy Van Winkle. And our finding is that that action would violate 244.040 sub 4, which is the use of confidential information for personal gain, as well as 040 sub 1, which is the standard use of office and conflicts of interest. So the proposed stipulated final order before you is for a civil penalty of $500. This is in accordance with the penalty matrix, and I have provided you with a copy of that matrix. When I, as a director, and when my investigators put cases through the penalty matrix, we assign the points, we deduct the points in accordance with the matrix, and it comes up with a recommendation based on the number of points. In this case, that recommendation is 4 points, which puts it in the 1 to 20% of the maximum penalty. So based on the matrix, the recommendation is a stipulated final order for $500.
Thank you, Director. The time is now, colleagues, for any questions to be asked of our executive before turning to Mr. Sterringer. Any questions? I'm looking for a hand. Vice Chair Payne, please.
Executive Director, when you get to the final table B of the penalty matrix and you have some discretion to go from 1 to 20%, how is that determination made? It seems like you landed on 10%, if I'm correct. Is that?
Thank you. Yeah.
Yeah.
The determination is made on a number of factors. Obviously, how much someone got out of it, whatever they were involved in, whether they were cooperative. And one of my considerations, which I recognize the commission may not agree with, but one of mine is that, are we treating all public officials with comparable cases the same? And so, given that some of the other people involved received the same stip offers and reached agreement on those. Another consideration in this particular case is that the actions of these individuals, in terms of having access to the liquor and having it sent to the store of their choosing where they would go buy it, predated their tenure at OLCC. In fact, at least one of the people interviewed during DOJ's investigation had been at OLCC for 30 years and said it predated her. So the practice clearly had been a long-standing practice. However, there also was no written policy, so it was could not be included in their official compensation package. But that was a consideration in terms of where in the matrix I would fall on. The other thing I would say in terms of the matrix is in the administrative rules, and it serves a number of purposes. Primary purpose, as I said, is that we want our penalties to be neutral, to treat everyone the same. We also want to let people know how we're going to reach those penalties. I mean, Ron created the matrix sort of so that there wouldn't be just people willy-nilly coming up with it. However, there are other provisions that the commission can consider. The commission has authority in the administrative rules to deviate from the matrix, but that requires that you either in writing or on the record state the reason for the deviation. There's one other provision to keep in mind, which is in the penalties in the statutes. ORS 244.390 includes a provision that says the commission, before imposing a penalty, shall consider the public interest and any other penalties or sanctions that have been or could be imposed on the public officials. So those are things that the commission can consider and keep in mind.
Thank you, Director. Just a quick comment. The director's reference to Ron refers to, for the record, Ron Burson, the predecessor to Executive Director Myers. Vice Chair, do you have a follow-up or not? Is that adequate for you? Thank you. I see Commissioner Mason. Please ask your question, make your comment, Commissioner.
Thank you, Chair. So for the Executive Director, what is the value of a bottle? For the rough value? Because I think, in the original report, it was several thousand could be the value of a bottle.
So the value of the bottle in Oregon is $329. I think it's $329.95 or something like that. In Oregon, you cannot resell distilled spirits. You can't order them from out of state. You can only buy them from OLCC's approved liquor stores. So what the other option, if anyone today wants to go buy a bottle of Pappy Van Winkle and there are none available in Oregon liquor stores, which generally is the case because Buffalo Trace makes it pretty rare, you would have to travel to a state where you could buy it. Now, that would either require finding a state where they have an abundance of Pappies on the shelf, which in my understanding is unlikely, or going to a state where you could purchase it from an online marketplace. And it's the online marketplaces that have, prices in the thousands. The difficulty in this case would be to prove at any one time, how would you determine exactly what they could get it for on that date and which state? There are only 6 states where you can have direct shipment to the consumer. But none of those are within easy distance of us. The closest is Nebraska. The others are back east. So I think there is an avoidance of financial detriment, but pinpointing and being able to prove exactly what that actual number would be, we do not have that information because,
Well, in part, I know we talked about that before, in the past, and that's part of the issue is if the value is significantly larger than this potential penalty. I think that's one issue. I think another issue is if you're a top official, you should probably pay a top penalty, despite the other commissioner or the other folks that we've dealt with in the past, all receiving a $500 penalty. And I think when you refer to public interest, if it's known that this the head of an agency is getting a financial benefit that potentially is greater than the value, then I think it hurts the Ethics Commission by going with a stipulated agreement that is less. And I think that would be the issue that I have with supporting this. And I wouldn't vote for it. I think that, there's a different standard level when you are head of an agency. And, I guess the other piece is, I know Mr. Marks said that this was only one bottle of purchase in your investigative process. If this was a long-standing practice, do we know that's 100% the case?
In terms of, thank you, Commissioner Mason. In terms of Mr. Marks's bottles, the difficulty in this case is obviously they were under a criminal investigation. A lot of the information that we have, other than their initial interviews with the internal investigation at OLCC, which is where he acknowledged that in the period of our jurisdiction, he believed he had obtained one bottle of Pappy's 23-year. Beyond that, what we have is, for the most part, DOJ's criminal records from DOJ's criminal investigation. And one of their findings was that due to the databases, the multiple databases at OLCC and at the liquor stores, it is not possible to trace one specific bottle to a purchase by this person on this date. So we would not be able to prove any additional purchases by Mr. Marks. All we have is his acknowledgement of one bottle.
Commissioners, just as a friendly suggestion, let's just hold off on some more substantive discussion of this matter. If you don't mind, for a moment, I would like to give Mr. Sterringer a chance to make any comments to us. He chooses to make, we'll ask him questions potentially, and then we'll move toward the idea of a general discussion and decision. If that meets with your approval, that's what I'd like to do right now, and then come back to the issues that Commissioner Mason and others may raise. So, Mr. Sterringer, thank you for being here. And if this intrudes on your vacation, we apologize, but thank you for being here.
Well, that's okay. Thank you, Chair Fiska, members of the commission. I do appreciate the opportunity to speak. And I first need to correct the very first thing I said. It appears that Mr. Marks was able to join us, so he is on the line here today. Just to address a few of the points that have been made, because I do know that the commission is very familiar with the facts of this matter now, based on the decisions that have already been made or the stipulations that have already been reached with a couple other individuals in the same boat. I want to focus on the concerns that have been raised. The first point, we do ask that the commission decide as a matter of consistency to resolve this matter in the same way that it has resolved two matters so far. That I think is borne out by the penalty matrix that the commission has adopted. And with respect to the concern about Mr. Marks being the top official at OLCC, there are really 2 points I'd ask the commission to consider. One is this point that the practice here did predate even Mr. Marks's tenure at OLCC. We recognize that's not a complete defense, but we do ask that the commission consider that this is something that for a very long time people didn't realize it may create concerns from a government ethics standpoint. And that once that was figured out, it was Mr. Marks who changed that practice. And then the other consideration is that, as was mentioned earlier, Mr. Marks did, according to the findings, only purchase one bottle during the relevant time period. I think that is fewer bottles than other individuals involved. And so one of the reasons I think that you would justify the penalty is that he is in essence being penalized more on a per bottle basis than other individuals. And if the basis for that is the fact that he was the executive director, you can justify it in that matter, in that manner. And then the last thing, I know I'm on a time limit here, but the last thing that I would want to make sure that the commission understood is that there's only one price, there's only one value for these bottles in Oregon. And Mr. Marks, just as the other individuals did, paid the amount that these bottles cost in Oregon. And that was established in the stipulated order here as $329.99. That is both the value of the liquor, but unlike in most circumstances where the commission is dealing with somebody who's obtained a benefit, Mr. Marks actually paid that amount. So it's not like he received this bottle for free and then it had a value of $329.99. He paid that amount. So when you're thinking about what an appropriate penalty is here, I hope the commission would conclude that not only is the $500 more than the value of the bottle, but we're talking about a situation where the individual paid the full price for the item that he received. And so it's not your typical situation where somebody is receiving something for free that has value that they're able to obtain. I'm certainly happy to answer any questions that the commission might have. And again, I do appreciate the opportunity to speak with you this morning.
Thank you, Mr. Staringer. Mr. Marks, if you are online and have heard that, I'll just give you one quick chance to follow up on your counsel. If you have any remarks for our consideration, Mr. Marks, if you're there and you want to speak, please do so.
I didn't plan on speaking, Mr. Chair. I was just going to observe and watch my able counsel carry out his tasks. Thanks for your consideration here. I think Bob has made the case aptly. Appreciate it.
Thank you, Mr. Marks. Okay, colleagues, now's the time to ask questions of Mr. Staringer in particular, and I'm going to turn first to Commissioner Mason. I may have stepped on one of your lines, Commissioner, so if you want to proceed to ask a question and make a further comment, please do so.
No, I mean, I think the director answered, thoroughly. I mean, I do think the value question, is unique because, I mean, my understanding from the report is, I mean, the folks at the OLCC were able to jump the line, in the lottery process to be able to get access to these bottles. And that's part of, the leftover or broken bottles or, these were special situations with how they were able to purchase these bottles. Is that correct, Director?
I do want to clarify. They didn't jump the line. They're not part of the lottery, but these bottles were in the reserve stock being held back in case something happened to bottles in the lottery. And once all the bottles in the lottery got delivered to the people who won the right to purchase them, at that point, then OLCC would be in a situation where they could then take the ones in the reserve stock and allocate them out. And where the jumping ahead is that they were made available to the OLCC people before anyone in the public or any liquor stores or anyone else could gain access to them.
Right.
Thank you, Executive.
And that, I mean, that's obviously a significant benefit because hardly anybody knew about this outside of the folks within the agency. So anyway, thank you for answering that, Director.
Thank you, Commissioner. Now's the time, colleagues, for any questions you want to ask, in particular, Mr. Staringer, based on what his testimony today. Looking for a hand in case there is any question for his consideration. Hearing and seeing none for the moment, the time now arises for us as a commission to discuss how to proceed in this matter and to move toward a decision. So I have some comments to make at some point, but I would prefer to open the floor to my colleagues for any comments you choose to make.
Chair.
How we ought to proceed today.
Sorry,
Please.
Chair. Commissioner Burke has his hand raised.
Oh, thank you. I did not see that. Commissioner Burke, please make a comment. If you can hear me, please proceed, Commissioner Burke.
Just one moment. He may not be able to yet.
That's fine. We'll just wait a moment to see if he
There,
can.
I think,
Yes.
yeah, I think I'm here now. Can you hear me all right?
Yes, please, Commissioner Burke, please proceed.
Okay, thank you, Mr. Chair. I'm thinking of the mission of the Ethics Commission. Our mission is primarily to educate, not to punish. There needs to be a penalty in a case like this. I think the $500 penalty is reasonable. I also think that part of the penalty is the fact that Mr. Marks, he's had his name in the press regarding this, and it's a political embarrassment. I think he's been duly educated. I think that others in his position have been duly educated. And I think this penalty is sufficient for the purposes of our mission. And so I would urge for passage of the stipulated order.
Yeah, Commissioner, appreciate the comments. I don't see a hand raised at the moment. Any other comments from my colleagues? Any of you online, or there's only two of us in the room today, and myself and Commissioner Thompson. Any other comments? Let me make a couple comments. I want to commend our staff first for working hard to bring OLCC issues to a conclusion, proposed conclusion involving the 6 public officials employed by that state agency who came under scrutiny for acquiring a bottle or bottles of high-priced liquor. I do tend to think that Mr. Marks, as director of the agency, has a higher duty to comply with Oregon ethics laws than do those who work for him. I know the penalty proposed in the order before us is related to the penalty matrix, which is an administrative rule that we adhere to. But as our executive has said, that administrative rule also does allow the commission to deviate from the penalty matrix. So I tend to think that the proposed penalty for Mr. Marks should be higher than the penalties that either have been or might be imposed on the other OLCC officials, recognizing that not all of those issues have been resolved. So I have mixed emotions about this, and I will leave it at that for the moment and see if my colleagues have any other comments to make on this issue before we decide how to vote. I would just amplify that I think a state agency head, like other high-level public officials, have a higher duty to comply with Oregon ethics laws than do those under them. And I can apply that standard across the board on both the executive and legislative, potentially even judicial branch if I wanted to do so. So with all due respect to Mr. Marks, I think he has a higher duty to respond than do those who work for him, all things considered. Public trust is an issue for a state agency head, just as in the case for those who work for him. It is at stake, public trust in the agency, but I think at a little lesser level than the executive, than the director of the agency. Vice Chair Payne, please.
Thank you, Chair. I have a procedural question for staff, for Executive Director. If we vote no on approving the stipulated final order as presented, does that mean it moves to a contested case, or is the staff able to renegotiate if Mr. Marks is amenable to renegotiating? What procedurally would happen next if the commission does not approve this stipulated final order today?
Executive, please.
Yes. So the case is currently in time waiver. So if the commission does not approve this stipulated final order, it doesn't automatically move the case to a contested case status because the case is still before the commission. We could either renegotiate the stip or bring back an investigative report at a future meeting and have the commission make findings and then proceed to offer all of the contested case rights, etc. As an alternative, if it is simply a matter of the number, the commission would have the option of amending the amount, and if it is acceptable, we could delineate the stipulation that is before you, and you could approve, if you vote that way, the chair signing the amended delineated stip, which would resolve that today. Not sure I explained that very clearly.
That latter point would require, quote, the other side,
It
unquote,
would
pardon me for that reference, Mr. Herringer, Mr. Marks. I don't mean to pitch you against us for the moment, but that would require their approval as well as our approval. It's not a one-way street, to state
Correct.
the obvious. And I said that for the record, but I believe that to be the case.
And so the question, if that is the direction the commission wishes to go, the question is, does the commission want to propose an amount and see if it is acceptable and proceed today, or Mr. Herringer and Mr. Marks and I can simply, the commission could not approve this and we would go back to the negotiation process.
Vice Chair, any follow-up?
I understand it. It may seem difficult for us to negotiate during the meeting today,
Right.
but I understand. I just wanted to see if it was all or nothing. Thank you.
Thank you, Vice Chair. Appreciate it. Commissioner Mason, I see your hand, please.
Thank you for clarifying all that. I do think that the commission should reject this and go back to the drawing board. I think it's appropriate in this case. There's enough dialogue on it. And I would be supporting a motion to reject the stipulated agreement.
Commissioner, any other comments from colleagues? Those online and the one person besides me in the room, any comments? Okay, hearing and seeing none for the moment, I'm looking for someone willing to make a motion for our consideration. And we'll see how that fares once the motion is made. Vice Chair, if you're ready, you may do so. If you'd rather defer to colleagues, you may do that as well. Commissioner Mason, your hand is up, please.
I mean, I would be willing to make the motion to reject the stipulated agreement in the case of Mr. Marks.
If that's your desire, Commissioner, please make the motion.
Is that not a satisfied motion? Director?
Yeah, I was quickly looking at the motion table to see. I don't know that we have a motion to reject. That's all I was looking
Okay.
to. We have a motion to approve, or I think the alternative to that is a motion not to approve.
I'd make the motion to not approve the final stipulated order in the case of Mr. Marks.
Thank you, Commissioner. Any comments on the motion now before us, colleagues? For the moment, hearing and seeing none, the administrator will call the roll on the motion to not approve the stipulated final order involving Mr. Steve Marks.
Commissioner Payne,
Aye.
Commissioner Burke,
Nay?
Commissioner Jancy,
Aye.
Commissioner Thompson,
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Chair McCauley,
Aye.
Chair Fishman.
Aye.
Motion passed 7-1.
Colleagues, what that means is that our staff goes back to the negotiating table with those affected by this issue. Any other comments to make on this, executive, in light of the decision? Mr. Herringer and Mr. Marks, I presume you understand what's happened in the last moments. Let me just say, without commenting on that for the moment, that we do appreciate your attendance here today and your comments to us. We hold them with respect. Whatever our decision is our decision. Thank you for your comments this morning and for appearing before us.
Chair,
Please.
could I ask if the commission would like to give me direction on an amount that they believe would be appropriate? Like if the commission's decision is effectively, we want to deviate from the matrix, it would help to have an idea of what that deviation should be.
Colleagues, I understand the question for our director. It's not a surprise to me, having heard it a couple of days ago. Let me just give you off the top of my head my quick bias there. I would prefer to leave the decision on the amount up to the negotiations between our staff and the respondents in this case. With that, I don't have a magic number in my mind. My only comment is I think that $500 is inadequate in light of the responsibility held by the individual involved, a state agency director. So I prefer not to propose a number. If somebody has a number to propose, we're happy to hear it. Colleagues? Any suggestions? Vice Chair, please.
I don't have a specific number to propose, but I don't know that we need to deviate from the matrix. It seems like there was some discretion used to be within the midpoint in table B. And I don't know that we need to use that discretion. We could go with the 20% instead of the 10%. I'm not saying that's something that you guys can negotiate, but I don't know that we need to deviate from the matrix. There certainly is discretion to go higher within that matrix.
That is true.
Vice Chair, that is an accurate statement. I appreciate the comment. It just prompts me to think about it. My only advocacy for a deviation is that I think we are allowed as a commission to deviate from the matrix, which is an administrative rule, if we cite a reason to do so that's plausible, to use a word. For me, the reason to deviate from the matrix, if it's necessary to do so, is the higher responsibility borne by a state agency director compared to those under him or her. I have that same perception about other high-level state government, local government officials. It's a perception that exists for me, but that would be the deviation I would think would be possible. If we don't need to deviate, so be it. Any other questions, comments, colleagues, before we proceed to the next item on our agenda? Happy to have any other comments for the record. Okay, that ends this item. Mr. Sterringer, Mr. Marks, thank you for your appearance today, and our staff will clearly be in touch with you, perhaps even momentarily, not necessarily during this meeting, but very soon. Thank you for your participation this morning.
Thank you.
Okay, colleagues, thank you for that process. I appreciate it. On our public session agenda, we will now move to item number 5 in our document. The items entitled by number, listed by number 23-128, 23-145, and 23-222. Our process will be the same as it was in the previous matter, in the sense that the first report will be by our executive director on behalf of various investigators who may participate in at least the Q&A, the questions and answers, or make any comments they choose to make as after the executive makes her report. And then we'll proceed through the process the same as last time in terms of questions, answers, comments, etc. So we'll pause just for a moment to allow our executive to return to the room in a moment and make the report on item number 5 on our agenda involving Shamia Fagan. The possibility exists that the principals involved in that matter are being consulted about coming into the room at this point. Please, Mr. Elkanich and Ms. Fagan, please sit at the head of the table there. Mr. Elkanich will find a chair that's at the head of the table. Thank you for being here. For the record, my name is Dave Fiscum. I am the current chair of the Oregon Government Ethics Commission. This is the time set aside for consideration of, as I just mentioned, but I'll do so again in your hearing, items number 5 on our agenda, which includes the following technical items: 23-128, 23-145, 23-222. We will consider all of those items as one. Our process will be first to hear a report from our investigators, which will be delivered today in lead by our executive. Then we'll have a chance to ask questions as commissioners of the report. We'll turn to you, Mr. Elkanich and Ms. Fagan, for your comments. Any comments you choose to make to us. Thank you for being here today. We may have questions for you, and then we'll proceed to discuss our decision on these matters, on this matter before us. Executive, please.
Thank you. So for the commission's benefit, these three separate cases all predate our current investigators. They were originally assigned to me and I believe Hillary and Monica at the time. So the current investigative staff took over these cases in December when we reactivated the investigations, and all four of our investigators worked on the cases. I'm presenting sort of a summary of the cases in general as well as the STIP, but the investigators are of course available to answer any questions specific to the information that we found. So item 5 is a proposed stipulated final order to resolve all three of the cases involving Shemia Fagan, former Secretary of State. So as brief summary, case number 1, the original case, 23128, alleged that she had a conflict of interest that was not properly declared and used for office with respect to the Secretary of State's issuance of the audit of the Oregon OLCC involving cannabis regulations, because on February 24th of 2023, she entered into a personal consulting contract with Verity Holding LLC, which is owned by the owners of LaModa Cannabis Companies. That consulting contract involved work in states other than Oregon, researching regulations and permitting processes in other states, and providing Verity with some legal advice or research regarding corporation formation. The individuals wanted to move from becoming an LLC to becoming a corporation with a board and had invited her to become part of that board. So the findings in terms of case number 1, there is no evidence of a conflict of interest involving the OLCC audit because between February 24th and April 28th, when the audit was issued, and even beyond that, May 3rd, when she resigned her position, there's no information showing that she took any actions that would require a conflict disclosure. Prior to February 24th, Verity was not a business with which she's associated. So she would not have any conflict of interest or any violation of the ethics laws prior to it becoming a business with which she's associated. So on the conflict thing, our finding and our recommendation is that there is not a violation. The second issue raised in case 1 was, did she, in this 2-month period, when she contacted someone at the Connecticut lieutenant governor to ask a question regarding who in Connecticut, do you know anyone in Connecticut who is involved in the regulatory or permitting process? That could have potentially been a prohibited use of office if she was using her position to benefit Verity, which at that point was a business with which she's associated. The evidence, though, is that she and Susan Bizewicz had developed friendships. They texted each other, usually involving sporting teams. And the information in this one and only text that Susan Bizewicz provided was publicly available information. So it does not appear that that in and of itself was a prohibited use of office. The third issue was the private employment test. So did she use her position or get this private consulting contract with Verity due to holding her position as Secretary of State? The test that the commission has issued in advisory opinions for when does a public official violate 244.040 in terms of obtaining private employment or a private financial opportunity. And it's a two-part test that basically says, did you take official action? Did you create the opportunity in your position? And did you create an opportunity for yourself by taking action as a public official? Or did you get the opportunity because of the position that you hold? In this case, applying that test to the question of, did Shemia Fagan violate 040 in entering this contract? There is no information in it. She didn't do anything as Secretary of State to create the opportunity. The question then is, did she get the opportunity because of the position she held? There are a number of factors that you could consider. She had a social friendship with the individuals. She was a licensed attorney at the same time. She's the one that drafted the consulting contract. There certainly, I think, is a benefit for companies to have a sitting Secretary of State on their board or on their payroll or in association. So the stip as to that case, the only question is, did she violate 040 by entering into a contract with Verity? So that's case number one. Case number 2, 23-145, was filed at the same time as the original cases. That was solely a question of, did she omit information from her SEI files? And the omission of information from the SEI was simply, she identified sources of income, HKM, her former employers, as a source of income. But question 7, as you might be familiar, asks SEI filers to identify any sources of income over $1,000 that would have legislative or administrative interests in your agency or in your position. And because the Secretary of State's office regulates the corporation division and the business registry, and HKM as a foreign entity registered out of state, but is registered with the Secretary of State. So she omitted to include HKM under question 7 on the 2 SEIs. Finally, case number 3, 23-222. Case number 3 involved questions about travel reimbursements. And there were basically 2 questions. One question was, did Shemia Fagan receive reimbursements to which she was not entitled, primarily involving these 2 tours of the state where she had her family and her dog accompanying her? The information we gathered, and her staff was driving separately. The information we gathered was that she did in fact receive $1,089 in additional reimbursements, because you can technically see the difference between what the state would have paid, being what it paid for the staff member, and the additional costs because she required the larger SUV and the larger or gas and the hotel rooms. The other question raised in that case was, were there double payments being made? And I'm not sure I adequately addressed this in the STIP, but there was an allegation in the complaint that she may have gotten reimbursed from the state for some flights or a flight back to DC, as well as gotten reimbursed from her PAC for the same expenditure. During the course of our investigation, our investigators were able to confirm that that was not the case, that the reimbursement from the PAC was not for the same tickets that the state had reimbursed her for. So in the end, it appears in case number 3 that there were violations of 244.040 and 244.120 based on the additional reimbursements that she received for the 2 tours where her family accompanied her. So, given all that, I have provided you with the penalty matrices for each of the 3 cases to show how I reached the proposed penalty of $1,600. So for case number 1, the matrix comes out at a 4. The only statute at issue is 244.040. So my recommended penalty was right in the middle of that. For case number 2, the recommended penalty for the SEI filing case is a letter of education. That is the exact penalty that we have given to every other SEI filing error case that has come before us. It would involve that she amend her 2 SEIs to add that missing material, and we would provide a letter of education. For case number 3, the proposed penalty would be $1,100. Again, it falls within the range that the matrix recommends. It also reflects a complete repayment to the state for the amount that she was reimbursed.
If the executive, if I can focus the discussion for the next moments, I think the time is now for my colleagues, commissioners, to ask any questions of our executive and or her investigators. And please understand that we will have time in a few moments to discuss how to proceed in such a matter as this once we hear from the respondents as well. But any questions for our executive or her staff based on what you've just heard? I have one quick question, hearing and seeing no hands at the moment. Executive, can you help explain or help provide context for me on the words on page 38 of our report that deal with that say, and I can read them, I suppose, but finally on or about May 12, 2023, after Shamia Fagan resigned, et cetera, based on weighing these factors, the commission contends that Shamia Fagan violated ORS 244.040 sub 1 by using her position to obtain private employment. The commission contends results, if we went to court, we would prevail, which is a suggestion, not an assurance. I know Ms. Fagan and her counsel may dispute that, but any comments about those lines on page 38 that deal with, I think, case, if I used my numbers right, 23-128.
Okay, so
Help me with that uncertainty on my part.
well, the uncertainty. So one, in any STIP that we negotiate, what is required is that we reach agreement on the asserted facts, but respondents are free to dispute any findings of whether we would be able to prove a violation in a contested case. And so they reserve that right. In addition, this particular type of 040 violation, the question of did she get the position because she holds her position, because she held her position at the time. There are any number of factors. They assert a number of factors that they contend would outweigh the factors that we contend show that she potentially got the position because of her position, the contract because. And one of those that they indicate is, in fact, that even after she was Secretary of State, she was no longer Secretary of State. Verity was, in fact, still wanting to provide her with this contract or have her continue with the contract, which would be a factor in concluding that the reason they wanted her as a consultant and on their board was not related to her being Secretary of State.
Thank you, Annie. I think you answered my question, but just to amplify, the reason I asked the question was on case 23-145, the SEI, there's a recommended letter of education embedded in our report.
Mhm.
Case 23-222, the trip expense issue, there's a recommendation of a penalty of $1,600, pardon me for using the word bucks. Case 23-128, there is no proposed penalty embedded in our document relative to that case, if I'm right. And if I'm not, please correct the record.
Yes, so the proposed penalty in the matrix that I sent to you was $500. So the proposed overall penalty here
Makes
was
1,600.
$1,600. So we had the 1,100
Thank you.
and we had the 500.
Thank you. That clarification, that helps me understand the relationship between it among three cases as part of one. Okay, colleagues, any other questions? Vice Chair, please, questions for the executive or staff?
Yeah, I guess I'm having a really hard time following how the conclusion was reached that the factors balanced in favor of potentially finding a violation on this one, because it says on one hand this, and then on the other hand, the arguments against. And if I'm understanding, the first on one hand is basically that she was Secretary of State, and that would be a benefit to anyone hiring the Secretary of State. And to me, if that's a factor that we are considering, anyone having outside employment as a public official would be in violation of this statute simply because they are a public official. And to me, I can't coincide finding a violation simply because it would be a benefit to any private company to have a public official like the Secretary of State. Obviously it's going to be a benefit, but I simply can't or would not find a violation and hold a public official simply because it provides a benefit. I feel like there has to be more there. And then I understand that the private company didn't open up a competitive process, and I understand how that would weigh in favor. But then I'm looking at the other factors that weigh against, and there are so many here that to me, it does sort of, if you're looking at the balance, explain why she didn't get this opportunity simply because she was Secretary of State. She did have a personal relationship, which explains why they wouldn't have opened up a competitive process, because they knew her, and that's how she got the opportunity. And she has this regulatory and board experience already. She was actively pursuing outside employment. And the fact that they wanted her to continue in that position after she was no longer Secretary of State. So for me, if this was coming before us and we were being asked to find a violation here, I would not be voting in favor of that. I feel uncomfortable simply saying that we would find a violation based solely on the fact that she was Secretary of State and they didn't open a competitive process, and that those are the factors that we are weighing against all these other factors. So I'm uncomfortable approving a $500 proposed violation for this violation. And I would like to reduce the STIP order to 1100, but that would be my preference based, and I would like to do what other commissioners think.
Let me insert for the record in here just a second, try to steer our discussion a little bit, though I see one more hand raised. I would like to just focus briefly on if there are any other questions for our executive and her investigative staff. And then I want to provide an opportunity for two people who are in the room to talk to us before we get into the discussion that Vice Chair has raised, if that's okay.
Yeah, Chair, my question is for the director on the investigative process.
Please ask the question, Commissioner.
So, and I appreciate Commissioner Payne's kind of teeing this issue up. So this case has been in the news, as of late. And of course, some of us, we read local news. And out of curiosity, I wanted to see how accurate some of the news was. And I was surprised, with a quick Secretary of State search, of Orstar, that and this is why I'm getting to the point of I'm curious on why the director and the investigators would leave this specifically out of the investigative report. Now, I think I know what the answer is, but the owners of the entity that we're talking about gave the acting Secretary of State a $5,000 contribution in March, and then another in April of $15,000 for a total of $20,000 after she was already elected and was holding the office. And so I'm curious on why the director or the investigators would leave. Like I said, I think I know what the answer is, but why they would leave that key piece out of the report, because that is a 2021, contribution from the entities that would eventually employ her.
Executive, you may answer that question, but I want to turn very quickly thereupon to our respondents, and then we'll have a more general discussion. Please answer Commissioner Mason's question.
So donations to a candidate's PAC, or, one, the PAC itself is a separate legal entity, and the commission has issued advice in the past to multiple people that a donation to the PAC is not a donation is not a gift to the individual. And the entity from 2021 through when she took office to February 24th, 2023, Verity LaMotta and the two owners of LaMotta were not relatives, household members, or a business with which she's associated. So that does not create a violation of the ethics laws.
Thank you for the moment.
Thank you for that answer.
Thank you, Commissioner Mason. Let me turn to our respondents today. Thank you, Ms. Fagan and Mr. Elkonich, if I'm saying that name right. You can help me with the pronunciation, please.
Thank you, Commissioner Fiscom. Yes, it's David Elkonich.
I've seen you before and I've said your name before, but I may have screwed it up more than once. So welcome here. This is the time reserved now for either or both of you to make a statement to us that you choose to make. We'll be happy to listen to it. You may appear in any order you choose. And for the record, announce your name before you make your comments to us. Thank you for being here.
Thank you, Commissioner. As I stated, my name is David Elkonich. I'm with the Buchalter firm. I represent Ms. Fagan. Before I make a few brief comments, Ms. Fagan would like to make a short statement.
Please.
Thank you. Good morning, I'm Shimia Fagan. For most of 2023, I have imagined the chance to sit here and defend myself. And then I spent the last 2 years in bittersweet reflection on my time in politics. And now I'm sitting here. And I know that my actions were indefensible. Embarrassing mistakes, bad judgment, and I'm sorry. And so whatever fine you decide to impose on me today, I will accept it.
Thank you, Ms. Fagan. We'll hold off on any questions we as commissioners might have for you until your counsel makes his remarks. If that meets with the approval of my colleagues, we'll proceed in that direction. Mr. Elkonich, please.
Thank you, Commissioner. Thank you all again for allowing Ms. Fagan the opportunity to appear here today. And thank you also for considering the proposed stipulation that the director has described. Ms. Fagan also appreciates the very thorough investigation that the director and her investigators conducted, and she respectfully requests that this commission accept and approve the stipulation. As Ms. Fagan noted, this matter has been pending for 2 years, and over that time, she has considered her actions and she's felt the serious consequences for the mistakes she made. She understands that she broke the public trust and regrets her prior conduct. She's here today, ready to accept accountability for her conduct and to accept the penalty in the stipulation. Thank you.
Thank you, sir. I appreciate both of you being here today. The time is now for questions from my colleagues, for either or both of you. Colleagues, any questions for what you've heard based on the respondents' comments in the last few moments? If there are such questions, please raise your hand and ask them. Okay, hearing and seeing none, executive, please.
Yes, I wanted to take an opportunity to respond to Commissioner Payne's comments because
Please.
I agree. I think in any case involving sort of the question of that private employment and why do you get the job, especially where the owners of the company are not willing to answer questions at this time. I believe they may still be under investigation elsewhere. But yeah, the weighing of the factors is an issue, and it was a extended discussion with Ms. Fagan's attorney, and I think the decision was that she felt, and he may be able to explain this better, that she would rather resolve this in one step and simply end it and include that here, recognizing that we may disagree on whether either we or they would succeed on this particular issue, but simply to resolve all of the matters and put this behind her was reasoning for including the $500 penalty for case number 1.
Vice Chair, any follow-up question? Thank you. Colleagues, comments, Commissioner Thompson, please.
Thank you, Mr. Chair. I appreciate Commissioner Vice Chair Payne's comments, but I also appreciate, as in the last case we just heard, that we're dealing with a respondent who is more than the executive director of an agency, as a statewide elected. So I think a $500 fine is reasonable. I think it needs to be more than a letter of education, but I also don't think that we need to pile on. So I am happy with the work the staff and Mr. O'Connor have done to negotiate this, and I'm prepared to support it.
Thank you, Commissioner. Any other comments? I've got a couple comments to make. Commissioner Mason, please.
Yeah, and I'm sympathetic for what the former secretary has gone through. I think it's been a very challenging time for her. I also think that she's been a maker of her own misery in some of this stuff. And unfortunately, I think there's a bigger picture. And, we have county commissioners, city councilors, school board members coming forward with a variety of situations that can be challenging for the commission to approve. And I think that, these penalties for, basically the second to the top official in the state of Oregon is not adequate. I mean, I think that you definitely need to have a top penalty for a top official, and she was the top official outside of the governor. I do think that it's wise to resolve this, and I know everybody does, but I think that the use of office to gain employment, it's pretty straightforward. I think when you go back to some of the preliminary review, back when Executive Director Burson was involved, I know Secretary of State called the commission's office, spoke with, I believe it was Monica, the investigator at the time, multiple times. She offered to put things in writing. She offered to put her in contact with the director. Neither one of those took place. I mean, I think there was opportunities to avoid some of these issues, at the time. I believe that, it's hard for me to see on the part where you credited 2 points on the metric, or on the scale, that was cooperation, where that shows cooperation in trying to resolve this. I know she's contesting on some of the other violations. I think the standard needs to be high, for both, frankly, for our investigators, for the executive director, and for people in front of us. And I think this is an inadequate penalty. I think it does need to be resolved, but I completely disagree with Commissioner Payne on where we're at. And I personally believe this commission should go back to the drawing board and come back with something that reflects, I think, what was, what the director previously stated in a different case on the public interest. I think there was a large financial benefit. I think there's multiple violations found. And I think that, this commission can do better with regards to the penalties in this case. Thank you.
Commissioner, any further comments from colleagues, either in response to Commissioner Payne or on any other issue before I make my own few comments on my part?
Commissioner Medler.
Oh, pardon me, Commissioner Medler, please proceed. Thank you.
Yeah, I wanted to echo what Commissioner Mason had said. I appreciate Ms. Fagan's coming forward and taking responsibility. And wanting to resolve this. And I also know that this has been challenging for her for the last few years, and I appreciate that. But I also do want to make sure that we look at this and put it in context to what happened. And I just agree with Commissioner Mason in that I think we need to make some really serious considerations about some of the penalties here because of the position that was held as Secretary of State for Oregon, and that it's definitely weighs into this. This is not just this is one of the top officials of our state, making decisions that should have been made differently. And we need to make sure that this doesn't happen again, and that we are clear with what is appropriate. And so I think that we need to go back to the drawing board as well and come up with something that is more reflective of the situation here.
Commissioner, appreciate it. Commissioner Burke, please proceed. You're on mute at the moment. You're now off mute. Please proceed.
Okay, thank you, Mr. Chair. First of all, I'd like to commend Ms. Fagan for her willingness to accept responsibility. We've had people come before the commission before that have really wrested, twisted and writhed to avoid responsibility, and I applaud that. I think that's an example for others going forward. Having said that, I too agree with Mr. Mason. This is more than just dealing with Mrs. Fagan, and transcends her willingness to be remorseful. This is an elected statewide official, different than a state agency head. And I think that we need to do a little more here to send the appropriate signal, not only to other elected officials, but to the people of Oregon, that these sorts of violations will be taken seriously. That's all.
Commissioner, appreciate it. Any other comments from my colleagues? Anybody, somebody? I don't see a hand. Couple comments from me. First of all, I want to commend the two respondents for the tone and character of your remarks today. We appreciate contrition and candor, and thank you for that this morning. I want to say also, I appreciate all the work done by our staff to bring this matter before the commission with a statutory deadline facing all of us only a few weeks hence. So for me, and I'm going to use the numbers of our cases with embedded in the one case 23-145, the one dealing with Ms. Fagan's SEI deserves a letter of education, which is similar to how we handle, if not the same as how we handle any other cases, such cases coming before us. For me, case 23-222 does not represent a wholly serious violation, even though there is a bit of confusion over approval for PIP-related spending for a family and a dog. The amount of reimbursement might be higher than it's appropriate. This is the case where our staff recommends a penalty. My view is that this would deserve perhaps a letter of education because after all, we're dealing with the person who's got a family and who's a statewide official taking a trip to see Oregonians. So for whatever it's worth, that doesn't strike me as hugely serious. The one that does catch my attention though is number 23-128 because it involves questions about the use of public office for private gain. Let me say that at the very least, I have some mixed emotions about what I consider to be the relatively small size of the penalty proposed in this case, all things considered. I know it's 3 cases, not just one. The reason for me is that Ms. Fagan held a high public office in Oregon Secretary of State, and I have felt over my years on the commission that holders of such high offices have a higher duty than lower public officials, no offense to them, to comply with Oregon ethics law is only because of the public attention they engender by the high office they hold and because of the public trust that they hold on behalf of all Oregonians, many of whom voted for them. So when those persons don't comply, I think they deserve higher penalties, frankly. And for me, this is true of the Secretary of State position. It's one of 5 elected by all Oregonians. At least all Oregonians have the option of voting. And the Secretary of State position is next in line to the governor if there happens to be a vacancy in that position. I recognize that the stipulated final order is based on our penalty matrix, and our staff has done a good job of honing in on that matrix, part of our administrative rules. But as has been stated earlier today, as commissioners, we do have allowance within that rule to deviate from the rule if we cite reasons for doing so. And for me, in this case, the reason for doing so relates to the high public position Ms. Fagan held, Secretary of State. Therefore, I would support rejecting our staff recommendation and asking staff to reopen negotiations with Ms. Fagan and or her counsel regarding a proposed conclusion that can come back to us for review. So that said, that's my view. I'd be happy to have any comments from others, my colleagues, about either what I've said or anything else you've heard in the last moments. Hearing and seeing no hands. Executive, do you have a comment? Please.
Yes, I
argue with me if you would, if you'd like to do so. Please.
a thorough argument last week or earlier this week. I don't remember.
Whatever it was.
A thorough argument. 2 points here. One of the points was a point that I made in that argument, which is the commission has the authority to deviate from the matrix, absolutely. But that does not mean the commission has the authority to impose penalties for things that are not violations of the law that are before the commission. So keeping that in, and that doesn't mean you can't do whatever you wish, but for case number 1, there is the one issue. That is it, did she get the private opportunity due to the fact that she held her position? So I absolutely recognize that there are all sorts of questions and about just the violation of the public trust and so forth. But the actual violation in front of us is the one very narrow issue. The other thing I would like to, as Commissioner Fiscom, as Chair Fiscom noted, we are somewhat short on time. And so it may be possible if Mr. Elkanich or Ms. Fagan I think there is a benefit to reaching a resolution. And I don't know if they want to propose, as I mentioned in the last case, we can amend the amount and vote on a proposed order that includes an amended amount. So I don't know if they want to propose.
Which, to go back to my earlier comment on the earlier case, would require both sides to agree on that before it came back to us, I'm presuming, am I right?
Yeah, yes, the commission would have to agree to whatever that amount was.
Okay. Further comments, colleagues, on how to proceed today? Just a second, Commissioner Mason, please.
Well, obviously, I think it's inappropriate to have negotiations right in front of us. Obviously, we talked about it from the previous case that, we should go back and discuss, but I also think that misses the, tone of the conversation, which it is inadequate based on, her position. I'm willing to make a motion to reject the current stipulated final order. My only question would be, is there for the director, is it a process where we need to vote on each three separately, or are these combined in one one stipulated order that we would vote to approve or reject?
Executive.
One vote. One order that is in front of you.
Applies to all of them.
Yes.
Okay, let's just pause for just a second to see if there are any other comments from my colleagues. I do want to provide the opportunity for Mr. Elkanich and/or Ms. Fagan, in light of what you've heard. I'll yield the floor to you just for a moment and any response you choose to make before we get toward a vote. So please, if that's the wrong move, I've now made anyway. So please proceed.
Thank you very much, Chair. I think as Ms. Fagan noted in her statement, we have negotiated the stipulation for the penalty pursuant to the matrix, but she is also comfortable with whatever dollar amount, if the chair and the commission chose to deviate, to resolve this matter. I think that she wants to take responsibility today, and with the deadline approaching, it makes sense to try to get this resolved if we can. And if the commission proposed a dollar amount to consider, we would appreciate that.
Thank you. Executive, any comments on that notion? That proposal, pardon me for the meaning with the word notion. I meant that seriously. So
the other thing I would point out is right now the 180 days ends on, I believe it's May 28th. Right. So if we were to delay any further consideration pending further negotiations, it could require us to hold a special meeting, come back with you, unless we were able to reach an agreement and establish a time waiver.
In light of the comments from our respondents, this is a think out loud, which is dangerous. My counsel would assure me of the danger of this. What about the idea of considering a motion to reject as is almost on the floor, and then asking your investigators to go into a different room and see if there could be an agreement? With that, procedurally, that avoids the notion of some of us trying to provide as commissioners a magic number that I don't have in my head. I just think the current number is low, whatever the number is. I appreciate the assurance from our respondents. They want to settle at some point quickly as possible. What about that approach?
That would be fine.
Okay, thank you. Colleagues, any other comments on that? Hearing and seeing none. Mr. Thompson, please.
With the comments I just heard and the ability to talk about this a little bit more before the deadline, I would be in favor of rejecting so we can talk a little more before we make a decision today.
That is now a motion to reject what's before us in these matters together as one stip. Case 23-128, case 23-145, and case 23-222. Is that an adequate motion, council, executive?
That's fine.
Okay. Colleagues, you've heard the motion. Any comments on it? Okay, hearing and seeing no hands, the administrator will call the roll on that motion to reject, please.
Commissioner McCauley.
Aye.
Commissioner Mason.
Aye.
Commissioner Mettler.
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscum.
Aye.
Motion passed 8-0.
Hey, if it's appropriate to executive, you could decide how to proceed in the next moments relative to the notion, the idea that it might be possible to reach an agreement in short order this while folks are here in the office, and you feel free to use the other room, you and whoever needs to go with you to that. You have one more item on the public session agenda, which we could defer till post-executive session if you're with your leave.
Yes, thank you. And I would remind you, the other item number 6, we're postponing anyway because of the time waiver.
Thank you. Please announce that for the record.
Okay, so for the commission's benefit, item number 6, the investigative report. Respondent's attorney has agreed to waive time on that matter because we'd like some additional time to review and respond to all of the material in the report so that they can provide an adequate response to the commission and potentially provide us with some additional information. So I agreed to waive the time, and we will pull it from consideration right now and bring it to you at a future meeting.
Thank you. Y'all understand that? The matter involving, if I'm going to say that name wrong, Bobo Subasic, Subasic. One of the OLCC issues is now pulled off the agenda for today. Time has been waived. The staff will continue working on that. It'll come back to us in relatively short order. All that said, Chair, what about the idea of conducting a brief bio break? Let's have a bio break and the appropriate individuals can adjourn to the other room and see what's possible. Please, we'll now adjourn. Pardon me, we'll now recess. Thank you, Commissioner.
Grimmett,
Bang me on the head, would you? Colleagues, including those online as well as in the room, we are now back in session. This is the Public Commission, Oregon Government Ethics Commission meeting for May 9th, 2025. We are back on the record after a brief recess. I will turn to our executive to make a status report to us if she is willing to do so.
Yes, thank you, Chair Fiscom Commission. On further negotiations, we would propose amending the penalty amount in for agenda item 5. Sorry, I gotta read upside down. Amending the proposed penalty for the 3 cases combined to $2,500. I would point out that the $2,500, especially in terms of case number 1, which appears to be the case at issue, represents in excess of the 20% maximum civil penalty in the matrix. It is 5 times what was originally proposed for that case. So I believe it represents a appropriate resolution of.
So to bring on the line.
Mr. Elkanich may want to.
Just one quick comment, and then please, Mr. Elkanich, you should feel free to speak and or Ms. Fagan. All I was to say, harkening back to our vice chair's earlier comment, if we were to approve this recommendation, if there was a motion on the floor to do so, that would mean that we are deviating, quote unquote, deviating from the matrix. We're not taking advantage of that extra room, and only that our vice chair pointed out. Is that for the record accurate?
Yes, you are deviating from the matrix.
Okay. We'll now wait. No, I appreciate that. Let's wait for a motion and allow Mr. Elkanich and or Ms. Fagan to make a comment to us. Please proceed.
Prefer to make a comment before the motion, and I just
do
clarify the agreement. I certainly appreciate the director's comments. I think we were actually under the impression that it would be actually a total, I believe, of 3,600. So it would be 2,500 a deviation on case 1, and then a letter of education on case 2, and then it would be the prior recommended 1,100 on case 3.
Thank you.
So it would be in total
36.
a recommend on case 1. It would be a recommendation to deviate. It would be, I think, 5 times what a prior the prior proposed amount was.
So, Mr. Elkanich, thank you for that clarification. The total then comes, according to this tentative agreement, the total comes to $3,600. Is that?
And a letter of education.
That is correct.
And a letter of education.
Yes, yes it is. Thank you very much.
No, I thank you for your clarification. Colleagues, please, any comments or questions on that, which is not yet a motion before us, in terms of this update you've heard from our executive as well as Mr. Elkanich? Hearing and seeing no hands raised, I'm looking for a motion. I'll turn to the vice chair unless somebody wants to take over for her in this motion.
I'm ready, Chair.
Please, Vice Chair.
I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Executive, please clarify the motion.
We need to amend the motion a little, saying you approve the
Amended motion.
as delineated, and then the rest of it would be fine.
Council, please.
Yes, I think just making the motion with the amendments as either stated and agreed to here, or specifying, if you want to specify the amounts, you can do that as well.
I would thank you. Thank you, Executive and Council. Vice Chair, please provide, and let's just assume the first motion you made has gone away because I threw it away. Please make a new motion, and just as a friendly piece of advice, if you could embed in your motion the total amount of money at stake, that would be helpful. Please proceed.
Yes, I will. I hereby move that the commission approved the amended proposed stipulated final order with the amended amount as 3,600 as the final order in this matter, and that the chairperson be authorized to sign it as such.
Thank you, Vice Chair. Appreciate the clarity of your motion. Any comments on the motion from colleagues? For the moment, hearing and seeing none. Are you ready for the question? I see heads nodding yes, at least the one head nodding yes. That means we'll have the motion. Administrator, will please call the roll on that amended motion relative to item 5 on our May 9, 2025 agenda. Please call the roll.
Commissioner Burke,
Aye.
Commissioner McCauley,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Nay.
Commissioner Thompson,
Aye.
Chair Fiscom.
Aye.
Motion passed 7-1.
Thank you, colleagues, for the your participation. Commissioner Thompson, please.
Maybe for you or for our staff, do we need to formally talk about the deviation from the penalty matrix?
No, it was, that was part of the conversation.
Okay.
I would assume, thank you for the comment, Commissioner. I would assume that either my comments or a general comment about the need for a quote deviation unquote under our OAR administrative rule that underscores this motion is part of the record leading up to the vote. And the executive assures me that if true counsel is that adequate on the definition of a deviation.
It is
The
part of
clarification.
for the record, and this is stipulated, so.
Thank you very much. Appreciate that. Okay, colleagues, you've heard the action, you've seen it. Mr. Elkanich, Ms. Fagan, thank you for being here today, for the clarity of your presentation, for the apology that Ms. Fagan you've rendered. We genuinely do appreciate your intent, your being here today and to be compliant with our agenda and our process. Thank you for your candor. Our staff will be you will get a letter from us that clarifies this for the record, to embeds this action in a letter. So thank you for being here today. Appreciate it.
Thank you very much.
Thank you.
Into exec, so you need to
Yeah, I will.
read the script, and I'm just gonna briefly.
Okay, media and colleagues, we're going to move into executive session now, and the media knows our provisions for it doing so. So the executive session will begin in just a moment. We'll wait for our executive to return from the hallway or the lobby, the real lobby. Okay, colleagues, I want to open the executive session.
Chair Fiscom, if I could just.
Please.
There's still a microphone
Oh,
here from the reporter, so I'm not sure if it's live or not.
thank you. As you know, investigator Fenstermaker, the media is allowed to attend under provisions of what I'm going to read, but thank you for that clarification. We'll make sure that that's taken care of before the door closes. Appreciate it. Thank you, Director. We're now going to convene the executive session for our meeting for the Oregon Government Ethics Commission meeting on May 9th, 2025. I'm going to now read the authority for undertaking this executive session. The media is welcome to stay in the room if it chooses to do so. That's their call. The following is now what I will read, a transcript developed by a combination of our staff and our counsel. The Oregon Government Ethics Commission will now meet in an executive session to consider preliminary reviews. Representatives of the news media and designated staff shall be allowed to attend the executive session. When we enter executive session, all other members of the audience will be asked to leave the room. Everyone currently joining the meeting online and over the phone, other than representatives of the news media, will be removed from the meeting. If your case is being heard in executive session, you will need to rejoin the meeting, where you will be held in the virtual waiting room until the commission is ready to hear your case. Our staff will text you on the number you provided them to let you know when we are about to hear your case. The executive session is being held under ORS 192.660 sub 2 sub F and ORS 244.260 sub 4. ORS 171.778 sub 4 and ORS 192.685 sub 1 to conduct preliminary reviews of ethics, lobby, and public meetings law complaints. Representatives of the news media are specifically directed that after the commission has made its determinations and adjourned the executive session, they may report on the preliminary review cases, agenda items 11 through 59, including the commission's deliberations and its final terminations. ORS 244.260 sub 4 sub D sub C and ORS 171.778 sub 4 sub D authorize the commission to deliberate and make its final determinations on preliminary reviews in executive session. Following the conclusion of the meeting, the commission will publicly disclose and post the audio and video recordings of the preliminary review executive session. Once the executive session is concluded, we will return to open session and welcome the audience back into the room. Finally, if any of the commissioners have any conflicts of interest related to any of the agenda items being heard in executive session, please make your conflict of interest disclosures now before we enter the executive session. Any such disclosures, colleagues? Hearing and seeing none, the executive session now is in force.
Chair, we need a few minutes to clear that online.
I presumed you did, and thank you for the reminder. And when the moment